Yes, sorry. Inclusion in the list. When do you want it?
Milord, may I have your lordship slip to mention a matter online, Milord?
Yes, yes, Mr. Dutt.
Milord, this is, Milord, a matter, Milord, which is appearing in my lord's list, Milord, as item number 109. So this is a bail in connection with an appeal. Milord, I am in custody, Milord, since 18th of January 2018. And Milord, the appeal was admitted on 19th of August 2019. I have filed this application on 27th of August 2019. Since then, Milord, the matter could not be taken up, Milord. If your lordship may kindly take up this matter, Milord.
Mr. Dotto, why wasn't the matter taken up after 2019?
No, it was once taken up in 2019 on 13th of November 2019.
Yes.
But Milord, there was certain confusion because Milord, of course, Milord, it's not that relevant, but still, Milord, the learned advocate for appearing for the state had taken the lower court records to his residence. So, Milord, certain orders were passed on 13th of November and thereafter. Milord, the matter got detracked because of Milord those issues, and thereafter, Milord, the matter could not be taken up. Now, if my lord may kindly, Milord, keep it, Milord, on a day convenient, or if I may make this request,
yes,
if your lordship take up that heading, Milord, on a day, so that, Milord, because I cannot, I have to do that, Milord, physically. This matter cannot be done
physically.
Yes, could it be
You want
next?
You want to join Mr. Chakraborty here?
Yes. And Milord, my leader is Mr. Bose, sitting on my left.
Yes. And how much time will that take, Mr. Dotto?
Milord, it should not take more than 10-15 minutes, Milord. Should not take more than 10-15 minutes.
Very well.
Could it be on Friday, Milord, subject to the convenience of the court?
Not Friday. You can come back on Thursday.
Very good. That is.
You don't want to come back on Thursday?
But it would be convenient if it is on Friday, subject to your lordship's sanction, Milord.
Very well, Friday.
Very good. I'm so grateful, Milord.
Yes. What is this, bail? Yes. It's an application of new matter. 2 months. Very well. You keep it on Poshudin. Yes.
Lord, Lord, with leave of Justice Biswas, Lord, I have.
Just 1 minute, Mr. Chakraborty. Any other division bench mentioning? Yes.
Lordship, yes, Lordship. Online mentioning.
The leave of
online mentioning item number 4.
1 minute, please. Online, you have to wait 1 minute. Yes.
Lordship.
The leave of your lordships may be permitted to mention to mandamus appeal, lordship. This is out of order dated 10th February 2023.
Yes.
By Justice Vivek Chaudhary, lordship. Now, these matters appeared in the previous circuits, wherein at the time of moving the same as motion, the state respondents, the SGD, they said that they will be filing in another, because they will be filing appeal because they are also aggrieved by the same order.
Yes.
Lordships, I have given them notice that 2 mandamus appeals are only for inclusion in the list.
No, but have they filed?
Yes, they have filed. They have filed.
They have also filed.
They have also filed.
Very well. You mention it on Thursday. We shall see. Yes.
Lordship, may I permit to mention one NDPS bail matter, Lordship, for inclusion in the list.
New matter?
Lordship, this matter filed on 2-3 months earlier, Lordship.
Then why have you not listed it in the previous circuits?
Lordship, this matter appeared, but due to I have not appeared, so that's why.
You have not been appearing in the court for last
no,
3 months.
Lordship, one day it does not appear. After that, this matter out of.
No, you come back with better reason. No.
Lordship, the accused person arrested on 16.
Yes. You mentioned tomorrow. We shall see. Yes. Any other division bench mentioning?
First appeal, lordship. This matter also appeared in the list from the last of the private respondents. They said that.
Very well. You mentioned next week. We shall see. Yes, Mr. Chakraborty.
Lord, with leave of my Lord Justice Biswas, Lord, may I trouble your Lordship, Lord. Item number 1 and 2 of your Lordship, Lord, single bench list, Lord, 2 Section 11 applications Lord, Justice Banerjee initially heard it, then Justice Tandon on the last day, Lord, fix it for disposal. I could not join virtually. The link, Lord, somehow got lost in between. So, Lord, I have come personally, physically, Lord, so that if my Lord allows me to today, anytime, I can move
So
it.
you don't think that there will be a single bench list today?
No.
That's I will not sit single bench. What do you think?
Thought of not taking any chance and mentioning it before. So kindly pardon.
If you do your Calcutta habits, you know what will happen, Mr. Chakraborty? You better wait and see whether the bench takes up the matters.
I will wait and see.
Yes. No. No. Yes, call on the list, please.
Lordship, may I be permitted to mention, Lordship, Lordship, online mentioning, Lordship?
Yes.
Item number 4, Lordship, online mentioning, Lordship. This is a statutory appeal, Lordship, it to be admitted. That's why I am mentioning the matter for admission.
What do you mean by statutory appeal? What is statutory appeal?
Lordship, the impugned by the impugned judgment and order, Lordship, the petition, the appellant has been convicted, Lordship. That's why I prepared an appeal.
And when did you file the appeal?
Within time.
You don't know the date. Come back and mention. Yes, call on the list.
Lordship, last
Mute. Yes, Miss Roy. Can't hear you. Call on the list, please.
Online mentioning, Your Lordship. Online mentioning, Your Lordship.
State, Your Lordship.
Your Lordship, online mentioning, Your Lordship.
Yes, why was this matter directed to be placed in this circuit on 2nd August? I can't understand. Microphone. We can't understand.
I prayed for adjournment on praying for certain document for this hearing.
Certain documents?
Yes, madam.
You wanted to do it before this bench?
Yes. Madam, I am ready, madam. Madam, petitioner is custody about 284 days, madam.
This is what, NDPS?
Yes, madam. NDPS. Allegation under section 21C of the 284 days, madam.
Yes.
Madam. And after filing of this bail application, my lord, charge sheet was submitted, my lord. And charge sheet submitted without chemical examination report, my lord. And
yes.
Certified copy of the charge sheet, my lord. And my main contention is that, my lord, in such a case, charge sheet submitted without chemical examination report and trial not commenced. In such circumstances, our Honorable High Court.
Trial not commenced?
Trial not commenced.
Till date?
Till date, my lord.
And the chemical examination, when was the charge sheet submitted?
My lord, charge sheet was submitted on 21st April 2023, my lord.
Yes.
And in such circumstances, my lord, trial not commenced and without chemical examination report, charge sheet submitted, accused trial granted bail, my lord. I rely to judgment.
Granted bail?
Yes.
What are you saying? Now, this is an application for bail. You're relying on a judgment.
Yes.
So say that.
Yes, ma'am.
And whatever copies you hand up, please, 2 copies for my learned colleague on the bench.
Yes, ma'am. Paragraph 3, the 11th portion, my lord, and another.
And when was it directed to be filed? The chemical examination report?
No,
yes, what do you have to say?
I rely to other coordinates.
No. What do you have to say?
The commercial quantity of codeine phosphate based drug has been recovered from the possession of this petition.
Commercial quantity?
Yes, ma'am.
And
2.185 kgs.
Yes, sorry, how much?
2.185 kgs.
And when was the charge sheet? When was the chemical examination report to be filed?
Charge sheet has been filed on 24th.
Chemical examination report, not charge sheet.
My prayer was made to receive chemical examination report, but not yet been received. My lord,
not yet been received.
Page 47.
47.
47 page.
47. Case diary.
Sorry, my lord, 33 and 34.
inventory report, and 48 is the prayer of chemical examination.
33 and 34.
33 and 34, that is the inventory report. And page 48, the prayer of the IO for chemical examination.
Report at page number 33.
Inventory report.
Inventory. 48, page 48 is the prayer of the IO for chemical examination. Only the month of April.
Yes, sorry.
Within 1 year, we have to receive the chemical examination report, and the prayer was made on
Within 1 year. Where does that say? Where is it provided for? That you have 1 year's time to get that report?
total investigation.
Total investigation. Charge sheet filed.
Charge sheet has been filed only April 1st.
There is no extension. There is no prayer for extension. Madam, I also relying another judgment.
Yes.
Madam, I also relying another judgment.
Charge sheet has been
Mr.
Supplementary charge sheet.
You're Mr. Shaha. Mr. Shaha. Mr. Shaha, don't irritate the bench like you do every time. All right. Yes. The records in the case diary show that a prayer was made by the SI of police to the director, State Drug Control and Research, on 18th December 2022 for the chemical report of the exhibits. Stop. The letter further shows that the reports, that the documents / exhibits were sent to the office of the director, capital D, on 14th November 2022 for examination and opinion. Stop. Next. Admittedly, comma, the chemical examination report is not on record, has not been provided to the IO till date. Stop. The defense of the recovered substance being of commercial quantity therefore becomes irrelevant in the absence of a chemical examination report. Stop. Next. The petitioner has been in custody for 284 days, and the charge sheet has already been filed on 21/4/2023. Stop. Next. Reliance in this respect is placed on a coordinate bench judgment in CRM NDPS 95/2023, where the application for bail was allowed on similar circumstances. Stop. Next. CRM 294/2023 NDPS is accordingly allowed and disposed of. Stop. Next. The petitioner shall be released on bail upon furnishing a bond of ₹10,000 with 2 sureties of like amount, one of who shall be local, and to the satisfaction of the special court under NDPS of Jalpaiguri. Stop. The petitioner shall not induce witnesses or influence witnesses or tamper with evidence. Stop. The petitioner shall also make himself available for trial, and whenever the petitioner is required to be present, Stop. The petitioner shall also not leave the jurisdiction of the concerned police station without leave of the court. Stop. তারপরে দেখবে CRM is accordingly allowed and disposed of in terms of the above. Last line to ওটা করবে।
I'm grateful to your lordships.
উপরে না এই লিখে দেবে, তাহলে এই অর্ডারগুলো আগে আমি বলে দিই যেগুলো আমরা অ্যালাউ করছি সেগুলো আগে ছেড়ে দেবো, কারণ অ্যালাউ করে তারপরে অর্ডার সাইন করবো না কেন। প্লিজ রাইট আপ দিন।
Item number 2.
I am for the state.
Madam, for item number 2, Mr. Sudip, item number 2 and 3, Mr. Sudip is appearing for the petition.
Who is appearing, sorry?
Madam, Mr. Sudip, my lord, he is out of station due to his treatment. My lord, kindly make it not today, he will come tomorrow.
Tomorrow?
Tomorrow. Yeah.
You want the matter to be there tomorrow?
I am praying for not today, he will come.
Yes. Adjournment is paid for on behalf of counsel appearing for the petitioner. Stop. List this matter on 16th August 2023.
Please.
Same order.
Item number 4.
I am for the
Mr.
state.
Item number 4, I am for the petitioner, lordship, from online.
Yes. Yes. 1 minute, please. Let us have the papers.
Lordship.
Is that you, Mr.
Lordship, may I-
Shahar?
Yes, lordship, yes. May I
No,
proceed,
no,
lordship?
not you. Your phone. We are asking.
No, lordship,
No.
I switch up.
Yes.
Lordship, the petitioner is one of the accused person. Lordship, the petitioner is in custody for 145 days as on today, lordship. The petitioner
This is not NDPS.
no, lordship. 302 matter. 302 matter.
302. Yes.
Yes, lordship. Then the lordship, during the course of investigation, lordship, the petitioner had surrendered before your lordship, before the learned court below on 23rd of March 2023, and the petitioner was immediately taken to the judicial custody, not police custody, for any purpose of interrogation and all. Lordship, however, after completion of charge sheet, lordship, the charge sheet, investigation, the charge sheet has been submitted on 9th of June 2023. Lordship, after filing of the charge sheet, it transpired after appreciating all the findings, lordship, 3 accused persons have been released on bail by this Honorable High Court by different orders, lordship. That is on
No,
6th
three
of July.
accused persons as in co-accused.
Co-accused, lordship. Yes.
Co-accused for the same
Yes,
the
yes.
same 302 offense.
Same. Yes, same. On 6th of July 2023, Rakesh De, who has been released on bail by this Honorable High Court, and subsequently, lordship, on 11th of July 2023, one Dia Modak and Priya Modak have been released on bail by this Honorable High Court. Lordship, however, the petitioner is standing on the same footing with the other co-accused person who have been released on bail.
So how
Charge sheet has
many
been
accused persons were there?
Five accused persons
Five.
have been charged sheeted.
Five
Three have-
of the 5, 2 have been released. So
Three have been released.
no, you only
Three-
said 6th July and 11th July. What about the third?
Yes. No, 11 July, both accused persons, Dia Modak and Priya Modak, have been released.
Yes.
And
Yes.
then, lordship, the petitioner is one of them, lordship. The petitioner is standing on the same footing with the accused person who have been released on bail.
Standing on the same
Charge sheet-
footing. So the level
Yes,
of
Lordship.
evidence against the petition is the same as the
Same.
3 others.
Yes, lordship.
Yes. What else?
Lordship, the petitioner is in
Show
custody
show
for
me
one-
show us the orders, please. No, 1 minute, please. The petitioner, show us the orders
lordship.
where they were released.
Yes, lordship.
ওনাকে দাও, একসঙ্গে দাও। One of them was a lady.
Yes, one Rakesh, they have been released on bail also.
And the order notes completion of investigation. What investigation?
The charge sheet has been submitted.
Very well. Yes. What do you have to say? 154. 164.
164 statement, and there is sufficient material against it. And this is the present.
No, but these Diya Modak has already been released.
Yes,
Yes.
Priya Modak released.
Priya Modak, Diya Modak released, and Rakesh, they also released.
Yes.
So they are all mentioned here. And the petitioner before us is who? Prosenjit
Kishore Munshi.
Prosenjit Munshi.
Yes, Rashid.
So Rahul Sarkar and Prosenjit Munshi are still behind bars.
Behind.
Yes.
আমার ছেলেকে অনেক আর মারলো, তারপর ধ্যান নিয়ে নিয়ে আসলাম, কিন্তু রাতে কমিট হয়েছে। আলাদা তারপর আমার ছেলেকে মারধর শুরু করলো। তারপরে একজন বেশিরভাগ টোটোতে উঠে দিল, কিন্তু কখনো প্রসঙ্গে টোটোতে ঢুকে আমার ছেলেকে অনেক মারলো। তারপর নিয়ে আসলাম নাকি, কিন্তু রাতে ভমিট হয়েছে। আবার পাশের লোক রাস্তায় হাসপাতাল নিয়ে গেলাম, কিন্তু সেখানে থেকে কুচবিহার এবার আলিপুর অ্যাম্বুলেন্সে ছিল, আমার ছেলে মারা গেল। Specific allegation was pursued. Subsequently, on a very simple.
There is.
Yes. There
is.
Yes.
Yes, Rashid. Yes. Rashid, initially there was no motive to kill the victim, Rashid, because the occurrence was held on Rashid on the evening of 8th of May 2023, 8th of March 2023. On that particular day, Holi was observed. Rashid, subsequently the victim suffered some problem at the midnight, and he was taken to hospital according to the statement and the FIR also. Rashid, when he was admitted in hospital, out of a complaint of his vomiting and all, Rashid, the victim has subsequently referred to Alipurduar hospital to.
Very well. We are not required anymore. Yes.
Okay.
We have perused the case diary. Stop. Although learned counsel appearing for the petitioner seeks to rely on orders passed by a coordinate bench where 3 other co-accused persons have been released on bail, we find that direct and much more serious allegations have been made against the petitioner in the 164 statement by the de facto complainant. Stop. Next, hence, we are not inclined to allow the petition or enlarge the petitioner on bail. Stop. CRM
at this stage.
At this stage, hence at this stage. CRM 386 of 2023 is accordingly rejected.
Obliged.
Lordship, I am for the petition, Lordship.
My lord, CD is required.
CD is required.
Yes.
Which is a local police station? Where is it?
Birpara, Birpara.
Birpara. So get it tomorrow, day after.
Yes.
Day after. Learned Counsel appearing for the state seeks an adjournment. Stop list this matter on 16th August 2023.
Number 6.
Yes.
Lordship, though the case relates to NDPS, on the not on made it on the ground of prolonged detention and relying to observation passed by the Honorable Coordinate Bench, relying the observation passed by the Honorable Apex Court, I am praying for bail before your Lordship. Now, kindly see, your Lordship, in this case, I am in custody since 29th July 2021. That is, I am in custody since 2 years and 20 days, as on date.
My lord, I'm praying for a short passover. Mr. Arjun Chaudhary is representing the state in this matter. He is before the single bench.
12 o'clock.
Lordship.
Number 7.
I am for the petition. Now, Lordship, in this case,
1 minute. Let us have the papers. Yes. Yes.
in this case, the matter relates to POXO. I am in custody since 623 days as on date. Now, on last occasion, this is a renewal of prayer for bail. On last occasion, my prayer was turned down because
When was it turned down?
at the month of March.
Yes.
Now, with the condition, after examination of the PG and the doctor, I can renew my prayer for bail. In this regard, your Lordship. Now,
No, that has been done.
now
When was that? When was that done?
Lordship,
When was that done?
last week.
Last week.
Lordship, this is the observation of the one minute. This is the observation passed by the Honorable Coordinate Bench in a similar situation. Tell me.
Yes. Please don't talk so loudly.
In a similar situation, that petitioner also renewed his prayer for bail with the direct as the PG and the doctor was examined. His bail prayer was allowed by his lordship. Situation is identical.
Yes. What do you have to say?
Page 70, 162 statement of the victim, and the page 42 medical of the victim.
Case number?
Page number 70, 164 statement, and page 42 medical evidence. So the deposition of the victim was
Maybe, but
One minute, please. Stop your arguments while we read.
You can keep it.
70.
70.
ভগবান ভগবান ভালো লাগছে না সঙ্গে চল আমি কি জমি দাবি জমি পাই আমি বললাম আমি আমি এগোতে আমি জল খেয়ে ফেলছি আমি জল খেতে গেলাম তখন পাশের বাড়ির মামা এলেন উনি মুসলিম ঘরে নিয়ে গেলেন আমার জামা কাপড় খুলে জামা খুলে
And where is the medical 42? Medical examination report?
42.
It is submitted on behalf of the petitioner that this accused petitioner is in custody since for a considerable period of time. Stop. Learned counsel draws our attention about the decision of coordinate bench in the similar case. Stop. So we praise that the petition filed by the accused petitioner paying for bail may be allowed. Next paragraph. Next paragraph. Learned counsel appearing for the state vehemently opposes the prayer and draws our attention about the particular pages contained in the case diary. Next, we have considered the submission advanced by both the parties, peruse the materials gathered in the case diary, particularly the statement of the victim recorded under section 164 of CRPC, as well as the medical document annexed to the CD. Considering the next paragraph, considering the entire materials placed before us and after considering the medical documents gathered in the case diary, we are not inclined to enlarge the accused petitioner bail. Hence, the prayer for bail filed by the accused petitioner is hereby rejected.
Grateful.
Stage.
Grateful.
Item number 8, one day accommodation, prayer for one day accommodation.
Sorry? Yes.
For one day
Adjournment is paid for on behalf of the petitioner. Release this matter on 16th August 2023.
Come for the petitioner. Lordship, in this case, your lordship.
1 minute, 1 minute.
In this case, your lordship, my only submission would be before your lordship that a memo of arrest is not signed by the independent witness, which is the mandatory provision as per the observation passed by the Honorable Apex Court in the D.K. Basu's judgment. In this case, your lordship, I am to draw your lordship's attention on an observation passed by the Honorable Coordinate Bench, but the violation of 41P, after passing that judgment passed by the Honorable Apex Court, the section 41P has been inserted.
বইগুলো এখানে রাখো কাউকে বলো দেখো yes yes
This is the first judgment passed by the Honorable Court in 2018.
Has been in custody for how long?
I am in custody in your lordship since 23rd May 2022. And this is the judgment. One indictment.
Yes.
May I get short person because there's judgment only one copy I have. I have to take it in photocopy. What possible? Because I have the only one copy, I'm getting photocopy.
Yes, what time do you want it?
Lordship, actually, I have the two observation passed by the honorable coordinate bench, but I have only one copy, like maybe.
Very well. Mr. Bhomik, you come back at 12:15.
Item number 10. Item number 10.
Yes. Okay.
I'm entering for short pass.
12:30.
Item number 11.
I'm appealing for petition. Allegation is under
1
section-
minute, 1 minute. Let us have the papers. Yes.
Allegation is under section.
Microphone, we can't hear you.
Allegation is under section 376 2F 511 of the Indian Penal Code, read with section 10 of the POCSO Act. Lordship, the petitioner is in custody for more than 8.5 months, Lordship. And allegation is, Lordship, prima facie, the allegation is very bad. The petitioner is the father of the victim girl. He allegedly tried to commit rape upon her daughter, Lordship. The
Yes.
victim is.
Upon his daughter. Yes.
14-year-old victim, Lordship. 14-year.
We don't want to hear much noise in the court, please. Silence.
Lordship, one thing is that
Yes.
charge has been framed, Lordship, and trial has started, but Lordship, on last 3 occasions, the victim girl has failed to appear before the learned court below. And Lordship, kindly see this order.
Where is the victim girl now?
I don't know, Lordship, I'm in custody.
Last 3 occasions she was not there. She did not come.
Kindly see this order, Lordship, order dated 8th of June 2023, Lordship.
Is POCSO Court Jalpaiguri?
It's Karshiang.
Karshiang. Facing the whereabouts. 11 July. What happened on 11 July? What happened on 11 July?
Same thing, Lordship.
Same thing.
Same. I don't have the order sheet, Lordship, but my instruction is that she has not appeared.
Yes. What do you have to say?
My lord, regarding that, my lord, I have not, my lord, answer to that, but regarding the 164 statement, my lord, it directly implicates the, my lord, accused.
No, that was told to us.
Let the deposition.
But last 3 occasions, victim girl. No. Have you been able to trace the victim girl? Because that is what is said in this order. It notes that trace her whereabouts. So have you met with any success on that?
To confirm it from the
Let
investigation
a
officer,
report
my
be
lord.
called for.
No, where is the IO? Where is the IO of this case? Is he
IO
present today?
is, my lord, IO is from Karshiang. Karshiang PA.
Very well. You tell us when we will keep this matter. We can keep it on the 16th, but the IO has to be there, present in court. Because if the victim girl is not traceable, and day after day the trial is going on and adjournment is being given on that basis, that can't be done for an indefinite period of time. So we are putting the matter on 16th. So Karshiang, he can come down. Very well. After considering the facts placed on record, which includes the order passed by the special judge, POCSO Court, Karshiang, on 8th June 2023, we are of the view that the IO should be present in court to inform the court on the whereabouts of the victim girl. Stop. Next, list this matter. On 16th August 2023, stop. The IO should be present.
I'm applying for the petition.
Yes.
Worship, the allegation is under section 448, 376, 323, 506, 109 of the Indian Penal Code. The petitioner is in custody since 31st of January 2023. Worship, 6 months and 15 days. The petition is current. Allegation is that the victim lady, she is 32 years old, and the petitioner went inside her room and committed rape upon her. This is the allegation, Lordship. And the alleged incident took place on 25th of January 2023, and the FIR was lodged after 5 days, Lordship, on 29th of January. Kindly consider that. Charge sheet has been submitted, Lordship.
Why are you saying 32 years? Is that relevant? We know that it's not under POCSO.
No, Lordship.
Then how will it help you? Yes.
There are allegations of rape, my lord.
Microphone, please.
This particular accused, my lord, went to the victim's house, my lord, allegedly, and my lord raped upon this victim, my lord. On that particular time, my lord, the mother-in-law heard some noises, my lord, when she came and tried to disturb the.
Yes.
My lord, she was again hit back by this accused, my lord.
And FIR after 5 days?
FIR after 5 days.
After 5 days. What is the explanation given?
No explanation.
No explanation.
But it is a, my lord, since it is a case against, my lord, to crime against women's rape case, my lord.
Sorry?
She was not, my lord, she was hesitated, my lord, that time, at that relevant point of time, my lord. She was shocked. Maybe because of that reason, there was delay in FIR, lodging the FIR.
Yes. And what is the charge sheet filed already?
Charge sheet has been filed.
Yes. And what is the status of the investigation?
Status of the investigation is, my lord, the charge sheet has been filed. After that, my lord, there is nothing in the reflection, no reflection in the case, my lord.
No?
Maybe no reflection in the case, my lord.
In the month of April, charge sheet was.
April.
Month of April.
And medical examination report is there.
Yes, my lord.
Medical examination.
Medical examination is there, my lord. Is there, my lord.
Hand over the city.
Which page? Which page? Medical exam. 13, 1-3. Medical examination. Considering we have considered the facts of the case, stop. The petitioner has been in custody for 6 months and 15 days, 15 days. Stop. The FIR was lodged 5 days after the commission of the alleged offense, and the charge sheet has already been filed in April 2023. Stop. We have considered in particular the medical report and considered it appropriate to release the accused on bail. Stop. Next, the petitioner shall accordingly be released on bail upon furnishing a bond of rupees 10,000 with 2 sureties of like amount, one of who shall be local, and to the satisfaction of the ACJM Mekhliganj. That's in Kuch Bihar, right? Comma Kuch Bihar. Stop. The petitioner shall not induce or influence witnesses or tamper with evidence. Stop. the petitioner shall also not leave the local limits of the jurisdictional police station without leave of the court. Stop. The petitioner shall also make himself available for trial whenever the petitioner is required to do so.
And after 4 days of incident, the FIR was lodged. Not
Five year bodole 4 করে দিও। After 4 days, FIR was lodged 4 days. CRM 442 of 2023 is accordingly allowed and disposed of in terms of the above. দেখো।
for the state.
Item number 6, so who is for the petitioner? Mr. Bhomik, you are there?
Now, Lordship, there are two accused persons who are arrested.
Both of them are before us?
One already expired during the course of his incarceration.
Yes.
Now, so for the present petitioner, there's two persons. There is Jiten Dev Burma, who is approaching with your Lordship, and there is Vinod Dev Burma, who already expired in the custody. Now, Lordship, can you see?
2 years, 2 years, 20.
2 years, 20 days, Your Lordship. Now, can you see the Lordship? This is the status report which shows the inordinate delay. We have no contribution.
In the trial?
Now, can you see, Your Lordship? I am in custody since 30th July 2021.
Well, the trial has been commenced.
No, charge has not been framed.
Charge?
Has not been framed. I have mentioned the status report. Can you see the status report at the bottom line? 7/8/2023 charge framing for framing of charge. But the charge
7th, 8th, 1 minute, please.
2023. Even on that date also, charge has not been framed. Now, my lord, in this context.
No, from 10th May 2023, charges were to be framed from 10th May. That's the first.
No, that is the first date of framing of charge.
Yes.
Charge was not framed.
Yes.
Next date was placed on 1st July 2023.
Yes.
On that date also, charge has not been framed. And the last date was 7th August 2023. On that date also, charge has not been framed.
And what is the reason for the adjournment? The delay.
I am not responsible for that. Now, Lordship,
yes,
I've already handed over one judgment passed by the Honorable Coordinate Bench, relying the judgment passed by the Honorable Supreme Court.
Which judgment have you handed up?
I've already handed over.
Which judgment has
Robi Prakash.
Robi Prakash.
Yes.
No, where is it? It's not here.
Lordship. Lordship, another copy.
Down.
Now, can you see your Lordship? Another. Now, the copy of Lordship. Kindly see the relevant portion is the paragraph number 4 in the second page. One judgment we have relied upon of Honorable Supreme Court in the latest judgment passed in July 2023.
Yes.
In that case.
No, that is Ravi Prakash.
Ravi Prakash.
Yes.
And that case also, two pleas were taken by the state. One is, he is the man of outer state. Number 2, commercial quantity of contraband were recovered from their custody. Now, considering that prolonged period of detention and relying the Article 21, which has overriding effect of Section 37, Honorable Apex Court was enlarged. The
yes, but in Ravi Prakash, it was 3.5 years.
3.5. And I am in custody near about 2.5 years.
2 years, 20 days.
2 years, 20 days. And that is for them 2 years, 15, that means 2.5.
No, why the charge has not been framed?
The charge has not been.
Who is for the prosecution? You.
I am for the state.
Why?
Lord, I am holding the status report. First of all, my learned friend has stated that one person has expired in the custody. Lord, the status report does not show that.
Then
irrelevant. Even if the person had been alive, why the question of my learned colleague is why it is taking so much time.
My Lord.
Yes.
Now, Lord, one person is absconding.
No person is absconding.
One
Can you see
person-
that?
Mr. Bhomik, you will have your chance. Yes.
Mr. One Somnath Saha of Tripura, my lord, is absconding, and my lord, for him, my lord, it is being delayed. That is the status report, my lord, it says.
So one indulgence I am seeking. As in respect of the absconding accused charge, a matter has been filed for the present. So the dates were fixed for consideration of charge. So from my little knowledge of law is concerned, until and unless one matter has been filed for the present, case cannot be proceeded.
Lordship may direct that the trial may start and a fixed time period may be given, my lord. Trial may be splitted if the absconding.
Charge already splitted for that charge has been framed.
Mr. Bhomik, if you get so excited, then we cannot hear the matter.
Lord, in that event,
Yes.
my lord, a fixed time period-
The accused has been in custody since 30th July 2021. That is 2 years and 20 days. Stop. We find from the status of the case that there has been inordinate delay in the progress of the trial. Stop. Although the accused has been in custody for a considerable length of time, charges are yet to be framed, despite 4 days being given for framing of charges, despite 4 days being allotted for framing of charges from 10th May 2023. Stop. The decision passed by a coordinate bench in CRM NDPS 458 of 2023 was on similar circumstances. Stop. The division bench relied in a recent Supreme Court decision in SLP, Special Leave to Appeal within brackets criminal 4169 of 2023, within brackets Ravi Prakash versus State of Odisha, close brackets, where the Supreme Court took into account the prolonged incarceration and the fundamental rights guaranteed under Article 21 of the Constitution. Stop. The facts in Ravi Prakash also involved inordinate delay. Stop. Next, relying on the division bench judgment, we are of the view that the application for the prayer for bail should be allowed. Stop. Next, the petitioner shall accordingly be released on bail upon furnishing a bond of rupees 10,000 with 2 sureties each of like amount, one of who shall be local, and to the satisfaction of the NDPS court. Where is this?
Jalpaiguri.
NDPS court, Jalpaiguri. Stop. The petitioner shall not induce or influence witnesses or tamper with evidence, and shall also not leave the local police, the limits of the local police station without leave of the court. Stop. The petitioner shall also make himself available for trial whenever the petitioner is required to do so. Stop. CRM NDPS 414 of 2023 is accordingly allowed in terms of the allowed and disposed of in terms of the other.
Gratefully over.
Lordship, prayer for not today.
Sorry?
Prayer for not today.
Lordship, last circuit, still
No, we are fixing on, if we are fixing on 16th. If further adjournment is made, we will dismiss it. We will reject it. Yes, the learned counsel opinion.
I know the advocate on record, she is suffering from high fever. And for that reason, she argued. It is not a case.
Very well. We are putting it on 16th.
I will ask her, otherwise I will appeal.
Very well. List is matter on 16th, August 2023 as paid for.
Item number 14.
I am appealing for petition.
Yes, learned counsel appearing for the state. Praise for adjournment. Stop list this matter on 16th August 2023.
Item number 15.
Lordship, paid for 1 day accommodation, Lordship, particular out of station, Lordship, 16, Lordship.
List this matter on 16th August 2023 as paid for.
Item number 16.
16th
for the state.
16 হয়ে গেল তো না 17 হবে Yes, no one appears for the petitioner. List this matter on 16th August 2023.
Item number 17.
Are you for the petitioner?
Item number 17.
Same order.
Item number 18. Item number 18.
My lord, for item number 16 to 20, Mr. Sudeep Goyal appearing. My lord, 16 to 20, my lord. My lord, kindly make it not good. 20, my lord.
16 to 20 একই সবগুলো একই অর্ডার হবে List this matter on 16th August 2023 as paid for.
Great.
Item number 21.
Same order.
Item number 22.
For the petition. This matter relates to NDPS.
1 minute, please.
But now, your lordship, I am in custody since 590 days. The only point would be to your lordship, for which I am paying for bail, non-compliance of DK Basu's judgment. That is a 41B lying vacant. And this is a
In the memo of arrest,
in the memo of arrest, your lordship.
41B.
41B. And this is a mandate of law as per the verdict of the Honorable Supreme Court in DK Basu's case, and for that, after that, lordship,
Show us.
that judgment. That will be the- Is the observation passed by the Honorable Coordinate Bench relying the DK Basu.
Last page you have pinned upside down. We can't read. Last page.
Last page, your lordship. If your lordship kindly take some pen to pen, that is the last. You lost it. Last page. এরকম স্টাইল হলো লাগানো
So there was no witness in the memo of arrest.
No. Even there is a observation passed by the Honorable another coordinate bench. If the raiding party signed as a witness, that is also not tenable in the eye of law, because there is a violation of the DK Basu's judgment and the section 41B of the Code of Criminal Procedure. In the same ratio, I am praying for bail for your lordship.
Yes, show us the memo of arrest, please.
My lord. Yes, my lord. This is true.
1 minute. Show us the memo of arrest.
My lord, so already handed over the city battalion prosecutor, which contains the memo of arrest. Column 10.
Yes, what do you have to say?
This is true. The column 10 remains
Microphone,
blank.
please. Yes.
This is true. The column 10 is remain blank, my lord. But the commercial quantity was recovered from the possession of the petitioner, my lord.
Yes, but what about this coordinate bench judgment? There also it was commercial quantity.
My lord.
Wasn't it commercial quantity, Mr. Bhomik, in the Shainur Bibi?
In this case, your lordship, 22 Shainur baby, much more than the present one.
Shainur Bibi?
Much more than the present one. In this case, your lordship, only 22 bottles cough syrup were recovered.
22 bottles cough syrup? We would have released anyway. 22 bottles of cough syrup, that should be your first and only submission to the court.
Actually, lordship, on last occasion, his lordship, Honorable Justice Chittranjan Das was-
You don't have to present any DK Basu's judgment or reliance, all right?
Lordship.
Yes, the petitioner has been in custody for 590 days. Stop. Next, the memo of arrest reflects blank spaces against the signature of the witness and the counter signature of the arrestee. Stop. Next.
My lord, counter signature is there, my lord. In the after
Yes, counter signature to record Shudu reflects a blank space against the signature of the witness. Stop. The Supreme Court in DK Basu versus State of West Bengal, 1997, 1 SCC 416 gave certain mandatory issued certain mandatory guidelines which were to be followed in all cases of arrest or detention, as well as preventive measures. Stop. Of these directions, the Supreme Court of these directions, the Supreme Court also held that a police officer carrying out arrest shall prepare a memo of arrest at the time of arrest and which shall be attested by at least one witness who may either be a member of the family of the arrestee or a respectable person from the locality from where the arrest is made. Stop. DK Basu, the decision in DK Basu was followed by a coordinate bench in CRM NDPS number 428 of 2023, which has been placed before us. Stop. We have also considered that the seizure, SEIZURE, the seizure involves 20 bottles of cough syrup. Stop. Next. Having considered the relevant facts of the case, including the memo of arrest and the judgment of the Supreme Court in DK Basu, we are of the view that the prayer for bail should be allowed. We are of the view that the petitioner has been able to rebut the statutory restriction under Section 37 of the NDPS Act. Stop. Next, the petitioner shall be released on bail in the event of arrest upon filing a bond of shall be released on bail in the event of a cricketer, shall be released on bail upon furnishing a bail bond of rupees 10,000 with two sureties of like amount, one of who shall be local, করে বাকিটা যেটা বলেছি আগের ওটা থেকে আর NDPS Act, 1985 হবে.
My lord, one indulgence, my lord.
Yes,
Kindly note my objection.
Yes. Learned, the objection of learned counsel appearing for the state is noted.
Grateful, my lord.
Grateful, your lordship.
Dakho.
Item number 9. Item number 9.
Same thing, my lordship.
What same thing?
The lordship just passed the order.
No, what do you mean? You have to place the facts. What same thing?
Lordship. No, lordship. My submission.
1 minute.
My submission would be with the lordship. In this case, one member of the rating party signed as a witness in the column number 10, which is also a clear violation of the 11 points.
Yes, show us violation of which point in DK Basu? Which direction?
41B.
41B. Show us the judgment in DK Basu and show us the part, please.
So then maybe passed on, fixed on at 2 p.m. subject to your lordship.
No.
I will get the DK Basu judgment from.
You should have got it. Yes, list this matter on 16th August 2023 for learned counsel to get ready in the matter.
Within 10 minutes I will get, because that is in soft copy with me, but just to get print out.
Very well, then why 16th August? Then after at 10 to 1. 10 to 1. 10 to 1. Order to pass korna.
Item number 23.
I hold the statement.
Item number
10 to 1.
Lordship, this petitioner was arrested, Lordship, on July 22, 2021, Lordship.
July 22, 2021.
2021, Lordship. And in this case, Lordship, charge sheet was submitted on September 2021. Lordship, till today, Lordship, the FSL report was not collected, no supplementary charge sheet filed, and Lordship, charge not even framed, Lordship. More than 2 years, Lordship. The position of this case, Lordship.
15th September
Yes.
2023 fixed for charge.
15th September 2023. Why? What have you been doing for the last 2 years? Why 15th September? Has been in custody from 22nd July.
Actually, my lord, supplementary charge sheet.
Sorry?
Supplementary charge sheet has to be filed.
Supplementary?
Where's supplementary charge sheet?
For CFSL report.
Yes.
For CFSL report.
CFSL report.
Yes, ma'am.
So last 2 years you have not got CFSL report.
Till today, charge sheet. They are praying for, but they are not sending the CFSL report.
Who is they?
CFSL authority. Their prayer made by the IO.
When was the prayer made? CFSL is chemical forensic. S stands for what? Substance.
Substance.
And L? You're not ready in the matter. Or?
Forensic science laboratory. CFSL sentence.
Drug control and research laboratory.
Just tell us when did you request for it? That's all.
My lord, copy is not there, but it mentioned in the charge sheet.
When it was sent. When it was sent.
It is the certified copy, so incomplete.
Where is the IO? Where is the officer?
He is from Bhaktinagar.
No. My learned colleague is asking you, where is the officer? Not from where is the IO should have been in court.
Not present.
It is the decision of the Supreme Court that at the time of hearing of the bail application, IO must be present before the court. You know it.
I will.
Then where is the?
I will communicate.
You are not in a position to give reply. Then IO's presence is necessary.
16th August. List this matter on 16th August 2023. Stop. The IO should be present.
I'm for the statement. I'm for the in this case, your lordships, earlier occasions, one report was called for from the jail superintendent, and the report has been produced before your lordship.
I can't. We can't hear you. Report called for by a coordinate bench.
This bench, your lordships.
This bench.
This bench. Coordinate bench, your lordships.
Coordinate bench.
Yes. Earlier.
That's on 4th August 2023.
7/8/23. 7th August.
The juvenile.
No, your lordships. NDPS commercial quantity. They are take defense or the medical.
No, medical officer, correctional home that petitioner is suffering, etc. Yes, what is where is the petitioner? In the correctional home? But what
Accused.
Yes, but says all this cancer and all this. What is all this?
Yes, so much. But that day.
Yes, Mr. Poddar.
Petitioner is suffering from gallbladder cancer, my lord. Bladder cancer, my lord. Then the earlier coordinate bench directed to submit a report. Report was placed that he is already suffering from bladder cancer, and thereafter coordinate bench directed to give medical treatment. Last coordinate bench direction.
Yes.
And therefore, my contention that my lord petitioner is still suffering from the cancer, no operation was made. And another thing is that my lord petitioner is custody about 2 years and 6 months. Till today, no witness was examined, my lord.
How many witnesses? Yes, how many witnesses?
Witnesses.
13 witnesses?
Yes.
And no one examined till date?
No, my lordship, regarding that aspect, there is no report status report else because
What do you mean? You're appearing for the state.
Yes, your lordship.
It's an application for bail and you don't know that there's.
Then their plea was that condition of the petitioner.
No, what is the stage of the trial? Whether charge has been framed?
Charge has been framed.
When?
Framed, your lordship.
When?
When charge has been was framed?
My charge was framed on 19 February 2022. This is the server copy of the
19 February 2022. And 13 witnesses, none examined after that.
This is the online case status report. Till today, no witness was examined. Only date for evidence. my lord.
What is the reason for non-examination?
Lordship, there is nothing reflection in the CD, your lordship.
Where is your IO? Where is your IO investigating officer?
Officer of Pattikara police stations.
Yes. The
Lordship, 950 grams brown sugar. Actually, they are taking plea that they are the ill and not in a position, and they are for the prayed for the medical ground.
whatever it is, why have you not examined a single witness of the 14 witnesses?
Prison status.
We are saying that that alone will rebut the statutory presumption. Absolutely not. Yes, the lack of preparation of the state in opposing the prayer for bail is significant. Stop. There is no information which is made available to the court as to the status of the investigation. Stop. The court has only been informed that the charge sheet was, that charges were framed on 19th February 2022. Stop. The petitioner next. The petitioner has been in custody for 2 years, 6 months. Stop. It is also undisputed that of the 13, that none of the 13 witnesses have been examined for the last, for almost 3 years. For the last 2 years, 6 months. Stop. The state does not have an answer as to why there has been no progress in the trial after framing of charges. Stop. Next, the woeful state of affairs in pursuing the trial and the lack of any explanation, comma, reasonable or otherwise, comma, is sufficient to rebut the statutory restriction under section 37 of the NDPS Act, comma, 1985, comma, in our view. Eta in our view kore arambho koro sentence ta. Next, we also note that the order passed by the last circuit on 7th August 2023, recording that the petitioner has been diagnosed with gallbladder cancer and requires urgent surgical intervention. Stop. The coordinated bench relied on a report dated 3rd August 2023 in this context, and noted that immediate corrective measures should be taken. Stop. Learned counsel opinion for the petitioner submits that no corrective measures have been taken in this regard till date. Stop. Next, the above reasons persuade us to allow the prayer for bail. Stop. Next, the petitioner shall be released on bail after furnishing. Same. Learned counsel appearing for the state opposes the prayer for bail. Correct of last paragraph.
Bail amount of bail amount.
10,000.
Take instruction from your concerned IO before submitting anything before the court. What are you doing?
Very well. So from now on, if we find that the IO is not present in court and is also sending insufficient instructions to counsel, we shall release and allow the prayer for bail on that ground without hearing any further submissions. As my learned colleague has said, the IO should have been here in court. None of the counsel have any definite instructions. What is this? Yes. Next. Pass over to.
20.
Recovery of 25 bottle of cough syrup.
1 minute. Custody since?
Custody since 296 since on 14 October 2022. Custody since.
Yes.
25 bottle of recovery and another thing.
Make your submissions properly, Mr. Poddar. We can't understand what you're saying. Yes, all of you, please leave the court and discuss outside. Yes, we can't even hear the submissions. Yes.
Arrest memo. At the time of arrest, my lord, there is no independent witness and there is signature.
No, is it a blank or does it have a signature?
Blank.
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 And what is the item seized? Commercial quantity?
Yes, 25 bottle of cough syrup.
25 bottles?
Yes.
Yes, what do you have to say? Very well. একটা যে order দিলাম না ওই ডিকে বাসু ওই একই টাইপের একই হবে আর এখানে হবে 25 bottles of cough syrup allowed.
Your Lordship, I am appearing on behalf of the petitioner. This is a renewal of bail application. The earlier occasion, the bail was rejected due to non-filing of charge sheet. The charge sheet.
No.
been filed.
Look at the order of 4th July 2023, coordinate bench, says list for dismissal. List for dismissal. 4th July 2023.
4th July.
4th July 2023.
No, item number 25.
Yes, Mithun Sarkar.
Mithun Sarkar.
So you don't know the 4th July says list this matter for dismissal under the heading for dismissal. And then 5th July. Yes, very well. 5th July says some point which you raised. What is that point?
Yes, those points are the charge sheet was filed without any chemical examination report. The petitioner is languishing in the judicial custody since more than 282 days. And in view of the judgment of the coordinate bench, that is CRNDPS 95/23, I am praying for bail.
We don't, if you make submissions like this, you think you mention the number and we know the judgment. What is this?
Sorry, ma'am. Without any chemical examination report, charge sheet was filed.
Yes, what do you have to say? For CFSL report?
Why the report was not collected by the concerned IO? What is the reason? Report prepared? Are you aware? Then I would take an instruction from your concerned IO.
Till date, the CFSL has not yet been filed.
Sorry?
No CFSL has not yet been filed.
Yes, admittedly, comma, the CFSL report has not been filed despite a request made for such on 20th November 2022. Stop. The petitioner has been in custody for 282 days and the charge sheet was filed without the CFSL report / chemical examination. Stop. Next, a coordinate bench decision in CRM NDPS 95 of 2023 has been placed before us, where on similar facts, comma, the accused was granted bail. Stop. Where on almost identical facts, the accused was granted bail. Stop. Next, we are accordingly of the view that act a line learned counsel appearing for the state cannot apprise the court as to whether the CFSL report will be received in future at any future date at all or not. Stop. Next, we are accordingly of the view that the prayer for bail should be granted and the facts are sufficient to rebut the statutory restriction under section 37 of the NDPS Act, 1985. Stop. Next, CRM 493 of 2023 is accordingly allowed and disposed of.
Grateful.
Last paragraph of the review.
Grateful.
I'm for the petitioner. In this case, your lordship.
1 minute, 1 minute. Who is for the state in this matter?
Who is for the state? Here, item number 26. Here, Nirmal Sharma. Matter is similar to 25.
Very well. Let it be. If a journal is paid for by your learned counsel friend, then why should we? 16th? List this matter on 16th August as paid. That's all right. As paid for on behalf of the state.
I'm for the petitioner, lordship. There is also non-compliance of 41. This is the memo of.
What again, DK Basu? What is the blank space here?
Nothing.
What?
Sure. I'm
Memo of arrest.
I've got the certified.
Show your learned friend first and then to the court.
My city is.
Who is this Azad Ansari?
He's the petitioner here.
No, no. There is.
But I have got the certified copy from the trial court.
Arjun Nayak. Who is Arjun Nayak?
But so far the certified copy is concerned.
No, it's completely different.
Lordship,
It's completely different. We will have to rely on what is there before us.
no, Lordship, one day accommodation I will collect the
Very well. Yes.
clarification why I got this kind of.
Yes, you collect the clarity. List this matter on 16th August 2023 as prayed for.
So 17th maybe.
17th.
You are for the state, take proper instruction from the concerned by this kind of difference.
Yes, you should be the one. Why should the petitioner run around trying to get the clarification? You should be the one to tell the court. How can there be a discrepancy in the memo of arrest?
Really surprised. Really surprised.
I'm keeping the copy.
Obviously, you can.
Lordship, item number 28, Lordship, short Passover, Lordship.
Let it be called on. 28.
Yes.
Passover after 10 minutes because we will rise at 1.
Lordship, 16, Lordship.
We can't understand what you're saying.
Lordship, can day after tomorrow your Lordship 16? 28.
Very well. List this matter on 16th August 2023 as paid for. On behalf of the state.
Lordship, I am for the petitioner, Lordship. Lordship, column number 10 is blank, Lordship, in the arrest memo, Lordship. Page number 16, 17, 18 of the column arrest memo, Lordship. 16, 17, 18.
Yes, blank. Or do you have a different arrest memo with you?
No, page 12, 13, 14.
Wrong city.
I apologize, I produced the wrong sleeve. Oh, right now I'm reading.
Very well. For 28, who is there for the state? Item number 29, sorry. Who is for the state? Yes, what about the arrest memo of arrest? Is it a blank? ওই একই order হবে, হ্যাঁ? DK Basu. Revert the statutory restriction in 37, the NDPS Act. देखिए एटा लिखिए.
Number 20.
What is it?
Earlier, art by your lordship. Just fairly something that he has holding the wrong signal.
That is which item?
27, Lord.
27. Very well. After this matter, we will call on 27 is order to the order cancel kore do. 27.
Matter can be disposed of. I am holding the rights. Genuinely,
Mr. Bhomik, don't talk out of turn, please. All right. We have told you that we will call on 27 after this matter. Next.
Number 30, Lordship, same as Lordship, column 10 is blank, Lordship. Page number 16, and it's Lordship.
Why it is happening? Where is the RIO?
It's a very unfortunate thing. In all the cases, it is happening.
Same order, DK Basu.
Very unfortunate.
And he's not even in court to explain why it's happening. Whatever questions are put to you by my learned colleague or myself, no answer. We can't expect you to answer. The IO must be here to answer. Next, that 27 Tadako.
Item number 27. 27, item number 27.
For the petition. Lord, the memo of press lying vacant, column number 10. May I handle this?
Yes, yes. No, so who is this Azad Ansari?
He has been arrested.
He's the one who's arrested.
He's the petitioner.
Signature is also necessary.
He's the petitioner.
Sorry?
He is the arrestee. His signature is also mandatory.
That has not been in the memo of arrest. Neither column 10 has been filled up, nor the signature of myself has been obtained.
Column 10 is blank.
Yes, DK Basur order ta hobe. একটা line add করে দাও.
We have given them.
In the present case, comma, not only is column 10 blank, which is supposed to carry the signature of an independent witness, stop, comma, the signature of the arrestee is also absent.
No, it is there. It is there.
Where is it?
It is there. It is there. Column 11.
No, you just now told us that that is blank.
No, that is there. 10 is blank. I said that is mandatory. That is there.
Column 10 is blank.
10 is blank.
Very well. শুধু ওইটাই থাক।
Lordship, one indulgence.
Yes,
one
yes.
line objection may be recorded, Lordship. This is a commercial quantity of tramadol, Lordship. 250 grams is the commercial quantity.
Very well. Learned counsel appearing for the
504,
state objects to the prayer for bail.
500. नीचे लिखे
Item number 9.
Lordship, I am for the petitioner. Here also. The memo was signed by one of the members of the reading party. Apart from the local person, respectable person or the relative of the arrest.
Yes, you are appearing for the state.
Yes,
No, who is this? Kurban Firozi. Kurban Firozi is the arrestee.
The column 10 was signed by one SI of police.
Who is this? Poribesh Seth. Who is this? No, column 10. Where is the signature? Poribesh Chetri.
SI Poribesh Chetri.
SI Poribesh Chetri.
Now in this case, observation part of the member of the reading was signed. That's a page number 10. Page number 2. There are also one member of the reading team or reading constable signed up. Page number 2.
Where is the discussion? Last page is not here. What is this? Last page is not here. আপনার আছে last page? Mr. Bhomik, please. This is not the way to get ready in a matter. Last page of the judgment not here. List this matter on 16th August 2023 for learned counsel appearing for the petitioner to get ready. 17th. 17th.
In this case, Lordship also 41B non-compliant Lordship column 10
Blank. Blank. Same already covers. মানে একটা ধরুন দিকে বছর জাজমেন্ট আইও করুক না করুক
Column is there.
হ্যাঁ কিন্তু কলম করতে হবে সুপ্রিম কোর্ট কি বলেছে দিকে বছর সেটা আমরা নাও জানতে পারি কিন্তু একটা তো কলম আছে সেখানে তো ফিল আপ করতে হবে 1 minute. Who is for the state?
Lordship.
Can you see the page number? First paragraph. Technical examination report here to be.
May I have a short possible, Lordship?
5 minutes.
Lordship.
1 o'clock.
Enough.
$33. No one is there for the petitioner.
Double filing, Lordship.
Sorry?
Yes, item number 1 and item number 33 same, Lordship.
1 and item. What was item number 1?
Nunu Srivastava. Same case.
Same case.
Same petitioner, same.
Yes. Did anybody appear for the petitioner in item number 1?
Yes, Lordship. Item number 1 appear.
Yes, Mr. Poddar. Very well. We are keeping it on 16th. You please examine and tell us. All right. Learned counsel appearing for the state submits that this application is the same as item number 1 in today's cause list. Stop. Next. Mr. Poddar, who is present in court and had moved item number 1 of today's list, is requested to inform the court of the status of this application on 16th August 2023. Stop list this matter on that date. You are Mr. Poddar, are you not? Yes, Mr. Bhumik. Yes, you showed us that No, just says will send me the report once it's prepared. How do we know it's a CFSL report? What is that? What does that stand for?
State Drug Control Research Laboratory.
There are more than one lab.
Sorry?
There are more than one lab. There are more than one lab for that. The drug control is there, TSFL is there, and central forensic lab is there. State forensic is also there. There are 4 labs.
So what do you have to say?
Lordship, my investigating officer sent special messenger to the concerned department for
Yes.
the purpose of obtaining the report. And he was informed that the report was not ready. And ultimately he had to file the charge sheet in confirmation with the PDF. It appears on the entry of the PD. Here. That's paragraph. And this is the provision 117 subsection 8 of the CFPC Lordship. Once the report is received, the subsequent supplementary charge sheet can be filed. And there is no bar in taking.
Yes, so when will you be receiving the report? In custody since when?
I'm in custody since 28th December 2022. The same matter was.
This charge sheet was submitted in June 2023, 22nd June 2023.
Same situation.
In a month or two, Lordship will be submitting. I hope in a month or two, the report will be collected.
Why, what do you mean you hope? Been in custody since June, no, the charge sheet was in 2023 and you've been in custody since December 2022. Coordinate bench decision is there. We can't decide otherwise.
Lordship, kindly record my objection.
Yes, of course.
And my submission that we are expecting the report.
No, yes, you've been expecting since December 2022.
It is submitted on behalf of the accused petitioner that he is in custody since for a considerable period of time. Stop. Charge sheet has all been submitted without obtaining the report which would be received from SDCRL. There is no immediate chance of commencement of trial. So he prays that the accused petitioner may be enlarged on bail. Next paragraph. Learned counsel appearing for the state vehemently opposes the prayer for bail filed by the accused petitioner. He submitted that in course of time, the report should be collected by the concerned IO, and there is no bar for submitting report after submitting after submission of charge sheet. Next paragraph. We have considered the rival submissions advanced by both the parties, and it appears that this accused petitioner is in custody since from
28th December 2022.
And in the meantime, charge sheet has been and the investigation process has been ended up by submitting charge sheet by the prosecuting agency. And considering the entire materials placed before us, we are of the opinion that the accused petitioner may be enlarged on bail. Next, our attention is drawn about the decision rendered by the coordinate bench in case of CRM NDPS now being number 95 of 2023, where the honorable court at the concurrent bench opined that since the report has not been submitted, the accused petitioner was enlarged on bail. Accordingly, the accused petitioner is released on bail, punished on punishing bond of rupees 10,000 of the like amount each, one of which must be local, subject to the satisfaction of the Calcutta. It is further directed that the accused petitioner,
1 minute.
The accused petitioner shall make himself available before the trial court on each date of hearing, and shall not induce or influence any of the charge sheet witnesses. Next paragraph. If any of the conditions mentioned above is not complied with, learned trial court shall be at liberty to cancel the bail without further reference to this court. Thus, the criminal miscase being number such and such is hereby disposed of.
Last কোনটা ডাকলে এটা? 32. ডাকো 33 ডাকো. No, well, let it be called on. Yes. Yes, learned counsel appearing for the petitioner wishes to withdraw the application for bail. Stop. CRM, দেখি এটা দাও. CRM 544 of 2023 is accordingly dismissed as withdrawn.
The matter in which case item number 1, same case, suspension order passed.
Same case? We can't hear you. Microphone, please. Microphone, please.
Two application has been filed, my lord. Earlier, item number 1, that has been disposed of.
33 and 1 are same.
Yes. For that matter, I am not facing this application.
Very well. The reason given for withdrawal is that item number 1 of today's cause list was also filed by the same petitioner. Stop.
Yes.
So how many petitions has Sonu Srivastava filed? 3? 2? No, there was another matter where we asked Mr. Poddar to. This is the one. Very well.
Will the division
Nobody's there.
Item number 62, Lordship. I'm appearing for this matter on 17th, Lordship. Advocate on record, Mr. Ashish
Very well. क्यों नहीं ना क्या এখন আসেনি? কি হলো দুটোর সময়? Yes, list this matter on 17th August 2023 as prayed for.
Grateful, Lordship.
Item number 63.
My lord, for item number 63, 64, 65, 67, 63 to 67, Mr. Sudhir.
No. Please wait. One by one.
Not today.
Adjournment is paid for on behalf of the petitioner. List this matter on 17th August 2023.
Item number 64.
Same.
Item number 65. Item number 66. Item number 67.
66 to adjournment holo.
Item number 67. Item number 68.
I am for the petitioner.
Yes. Yes.
And I am for the
Who is for the state?
CBI.
Sorry?
The learned deputy solicitor general appeared, so
We can't hear what you're saying.
earlier occasion, my lord, Mr.
Microphone, please.
My lord, learned deputy solicitor general, Mr. Sudipto Mujumdar is appeared and Mr. Ajoy Singhania.
Very well. No one appears for the CBI. Respondent CBI. Stop. List this matter on 16th August 2023 as a last chance for the respondent to appear. You had taken an adjournment on the last day. Next. Next. Very well. No one appears, Sakirada. Learned counsel appearing for the CBI seeks an adjournment. Stop this matter on 16th August 2023.
Item number 69.
Lordship, I am for the petition.
Adjournment is paid on behalf of the state. This matter on 16th August 2023.
Item number 17. Item number 17.
Same order.
Item number 71. 71. Item number 71.
Who is for the petitioner? We can't hear. What? Sorry?
Stating the petitioners to comply with the 41A notice. My lord, they have complied with the 41 notice, but the petitioners are not there, my lord.
Yes, no one appears for the petitioners. Stop. The order passed by a coordinate bench in the last circuit directed the petitioners to comply with the notice issued under section 41A of the CRPC. Stop. Next, list this matter on 16th August 2023 as a last opportunity to the petitioners to appear in the matter.
For item number 7, we are praying for 1 day adjournment.
List this matter on 16th August 2023 as prayed for on behalf of the petitioner.
Item number 7, for the petitioner. My lord, this case leads to 498A, 325, 354, 354D, and 509. Now, before praying for bail, I'm the Joy Lordship kindly attention of the page number 9, the reading complaint.
No, who are the petitioners before us?
I am father-in-law. Husband only got the bail. And for
Father-in-law?
for that reason, I have annexed the order of the page number 11.
Only father-in-law before us? Page 11?
11. That the husband already got the bail by the honorable court.
The 164 of the.
Now, Manoj, can we gone through the 8, 9? There is a written complaint. Enter allegation in the impugned FIR against the husband for torture. Just to make myself as an accused in this case. In the second part, she stated in an FIR that I tried to outrage her modesty. And
Page?
who is the
Page?
Page, your lordship, 9 and 10. Just to make the case against me, a story of outraging modesty has been incorporated. Now, can you see the page number 10, the last from the bottom line? May I permit to read out? 16/5/2023 তারিখে আমি লোক মারফত খবর পাই যে আমার স্বামী অন্য মহিলাকে নিয়ে পালিয়ে গেছে।
Yes.
This is the genesis of this case.
Yes.
And just to implicate the father-in-law, some story of outraging of modesty has been incorporated. Husband is not there. As her husband allegedly fled away with another lady, which inspired her to lodge a complaint against the husband, and being the unfortunate father, I have been also.
The FIR is not corroborating with 160. The FIR is not corroborating with the 164. In 164, she has stated that the father-in-law outraged her modesty, but in the FIR, it is not stated so.
There are admittedly discrepancies in the FIR lodged by the victim and the 164 statement given by the same victim or de facto complainant?
Victim as well as de facto complainant.
Victim as well as the de facto complainant. Stop. Next, it also appears that the husband of the victim girl was enlarged on bail by an order of a coordinate bench on 5th July 2023. Stop. Next, we are hence of the view that the application for anticipatory bail should be allowed. Stop. Next, in the event of the father-in-law is before us. The father-in-law of the victim is before us. First line. Next, in the event of arrest, the petitioner will be released on bail. upon furnishing a bond of rupees 10,000 with 2 sureties of like amount. Stop. The petitioner shall cooperate with the investigation and make himself available for trial or for any other purpose before the jurisdictional police station as and when the petitioner is required. Stop. The petitioner shall yes, the petitioner shall also abide by section 438(2) within brackets 2 of the CRPC. Stop. Next, CRM A 576 of 2023 is accordingly allowed and disposed of in terms of the above.
If you oblige.
Time for the petition.
Yes.
Not today, Lordship. No.
A judgment is prayed for on behalf of the state. Stop. List this matter on 16th August 2023.
Well, time for the petition. Allegation under section.
Yes, who is for the state?
Not today, Lordship.
Same order.
Lordship, 76 also no city.
Same order.
I for the state matter of CD not it is.
A judgment is prayed on behalf of counsel appearing for the state on the ground of the CD not being available. Stop. This is matter on 16th August 2023.
Get for the item number 78.
Time for the petition.
Same submission, the CD has not yet.
Same order.
Item number 79.
I'm applying for the petition.
Item number 79. Not today.
Why?
CD not.
Why CD is not produced?
None of the matters the CD is here. This list has been made available to us from Saturday. Then
Please send the message. Perhaps tomorrow.
What? What is the reason?
We have to already send the message to our the concerned PS. Perhaps it come 16th or so.
ask the officers also to be present in court on 16th. Same order.
Item number 80.
একটা লাইন অ্যাড করে দিও, the concerned officer should be present in court on the next date. প্রত্যেকটা অর্ডার এই লাইনটা দিই যেখানে যেখানে প্রেয়ার চাইছে।
Item number 81. Item number 81.
We can't hear you. Microphone, please. Yes.
Allegation is under section 379, 411 of the Indian Penal Code, section 14A and
We can't understand. Please speak clearly into the microphone and move the microphone. We can't even see you. Yes.
Application is under section 379, 411, read with section 14A and 14C of the Foreign Service.
Yes. Yes. If you're not ready, take time. Don't hesitate. Why don't you say it? Yes, learned counsel appearing for the petitioner seeks an adjournment. Stop. This is matter on 16th August 2023. The learned counsel does not seek to press the application. Stop. Yeta dao, kagosha dao. CRM A of 597/2023 is accordingly dismissed as withdrawn. Interim orders of any shall stand vacated.
Lordship, 83 is not, CD is not available. CD is not available, Lordship.
Same order code.
CD is not available.
প্রত্যেকটা order ওটা থাকবে না, the concerned officer should be present ওটা থাকবে, same order.
I'm for the petitioner. The allegations are under section 21C.
Wait, let us have the yes.
Well, the allegations are under section 21C, 25 and 29 of the NDPS Act.
The microphone, we can't see you. Yes.
Petitioner is the owner of the vehicle, my lord. Nothing has been recovered from him. His name only transferred from the statement of the OA.
Yes. Yes.
What is your submission?
Lordship, page 84 CFSL report is
84.
page 84.
One.
Yes, what does 84 show?
Lordship, CFSL report.
CFSL report?
The report is not there.
What is your submission?
What is your submission in respect of involvement of this accused petitioner?
Lordship, petitioner is the owner of the vehicle.
That is all you have to say.
And the accused petitioner is the principal accused and habitual offender. And seizure list page number 9 and 4 packet of syrup containing 30 bottle each.
I'm the owner of the vehicle, my lord. Nothing has been without from me, my lord. The driver was running the vehicle, my lord. From him, it has been seized and driver is in custody since lawsuit. I'm the owner of the vehicle, my lord.
My name has transferred from the driver of the
Yes. But you're the owner of the vehicle, isn't it?
Somebody has not been for me. Section 30 not applicable on me.
We'll take the dictation.
Dictation.
Section 25.
Section?
25.
I am the liability between the owner of. That is, every owner has the liability.
Very well, yes, apni dictation.
It is submitted on behalf of the accused petitioner that he is the owner of the vehicle, which vehicle and owner of the vehicle, and is not involved in with the offence arrest. So you place that the custodial interrogation in respect of this accused petitioner, custodial interrogation in respect of this accused petitioner is not necessary. Next paragraph. Learned counsel appearing for the state submits that there is sufficient materials which indicates about the learned counsel appearing for the state submits that there are sufficient materials which indicates about the prima facie involvement of the accused petitioner with the alleged offence. So he prays for rejection of the charge sheet petition. CS submitted. CS and
What is pending?
charge sheet has not yet been submitted.
Yes.
That's
No, I don't say it. When was he charge sheet pending since when?
The case initiated
When was the case initiated?
1st April 2020.
1st April 2023. Very well. That's it. Expedite.
Learned counsel further submits that the investigation process is still going on and charge sheet has not yet been submitted. Yes. We have considered the submission advanced by both the parties, peruse the materials placed before us. It appears that the investigation process is still going on and the documents indicates about the prima facie involvement of the accused petitioner with the alleged offence.
Allow me to place some
Alleged offence.
coordinate base or allow me to withdraw this application.
Don't submit in such a way.
There are judgment of the coordinate bench wherein.
Don't submit in such a fashion. Your submission is over. You won't believe it.
Allow me to withdraw the investigation. I'm not placing the application.
Investigation is
going on.
Of the accused petitioner cannot be ruled out at this stage.
Allow me to
So the
not place the application.
anti-Semitic bill, which is extraordinary to the anti-Semitic bill, which is extraordinary in nature, cannot be granted to the accused petitioner. Accused petition under section 430 CPC is hereby rejected.
You should have made this prayer at the beginning. Why are you making it when my learned colleague is dictating? Then why are you not here with the judgments? You should have shown the judgments.
I submitted that.
No.
Why you have not come prepared?
No. You cannot make that prayer once you see that the order being dictated is going against you. How can you make that prayer? No. You should have made that prayer when the matter was being heard. You should have been ready in the matter.
Sure.
Change Yes, learned counsel appearing for the petitioner seeks an adjournment. Stop list this matter on 16th August 2023. Same order. Same order. Yes, learned counsel appearing for the state seeks an adjournment. List this matter on 16th August 2023. Same order. Yes, same order. Yes, same order. Same. What is it? Who is your senior? Who is going to argue the matter? Yes. Why is he not here? Treatment only for 15th August. From last circuit, he's also out of station. Very well. Yes. But then he will be here on 16th. All the matters you're saying 16th. Yes. Same order. Same order. Same order. Same order. Yes, next. Yes. Not this week. Why? Not here. Who is she? Who is the counsel? Sorry? Yes. Adjournment is prayed for on behalf of counsel appearing for the petitioner. Stop. List this matter on 21st August 2023 as prayed for.
My senior Miss Suman Senevis is out.
Sorry?
My senior Miss Suman Senevis is out of station.
Don't correct all these things. Let him at least tell the name. Yes.
Suman Senevis is out of station, my lord. For personal difficulties, kindly fixed it on 18.
Yes. List this matter on 18th August 2023 as prayed for on behalf of the petitioner. Next. Yes, 102. Who is there?
102.
No one appears for the petitioner. Then make your submissions, Mr. Bhumik. Yes, adjournment is prayed for on behalf of the state. This is matter on 16th August 2023. Next.
103. 103.
No one appears for the petitioner. List this matter on 17th August 2023. Doctor. এদের একটা মেসেজ দেওয়া উচিত যে আমরা প্রথম দিন বসে কাজটা করতে এসেছি মানে বেড়াতে যাওয়ার জন্য আমরা
Lord, I am for the petition.
Yes.
Lord, this is a case under section 341, 325.
1 minute, let us have the papers, please. Yes. Adjournment is prayed on behalf of the state. Stop list this matter on 16th August 2023. Next.
I am for the petitioner.
Who is appearing in 105?
105.
Lord, this is a case under section 448, 325, 376, 511, 427, 506, 31 of the Indian Penal Code.
Yes.
My lord, in this case, the bail
What is
order
a can? What is a can for? Oh, this, yes.
for the modification.
Yes, yes, yes.
My lord, in this case, bail order was passed in the 7th of November 2022.
Where is the order?
My lord, annexure P1. Annexure page number 9.
Yes.
My lord, with the direction to appear before this lower court 15 days. My lord, at that time I was sick. My lord, kindly see annexure P2.
So you were directed to appear before the CJM Jalpaiguri within 15 days?
Within 15 days. My lord.
And then what happened?
My lord, I was sick. Before
You were
this
sick,
order.
but
Yes,
this order is of November 2022.
Yes, my lord. Kindly
Then?
see annexure P2, my lord. Kindly see annexure P2. The medical document I have annexed.
And when did you file the present CRAN?
My lord. In the month of February, my lord.
February.
2020.
But the order was of November. So you were 15 days means 22nd. 22nd November 2022. You were supposed to appear. And you filed the application in February. What do you have to say?
My lord, there is a clear direction of the honorable court. My lord, 15 days time period was given. But my lord, the bona fide has not been shown by the petitioner. My lord, he has approached this court after almost 3 months.
And this CRM, that was anticipatory bill.
Yes, my lord, it is anticipated. CRM 504 of 2020.
And you don't want to appear before the lower court, then what happens? Yes.
Let him, Lord, let a time period be given, my lord, 2 days or 3 days. Within that period, he will go and surrender. Otherwise, my lord, bail be cancelled.
Very well. Yes.
I'll kindly make it 7 days or 15.
No. The present CRAN, CRAN 1 of 2023 is for modification of the conditions imposed by the order of a coordinate bench passed on 7th November 2022. Stop. The order was passed in an application for anticipatory bail with the condition that the petitioner should appear, that the petitioner should surrender before the learned CJM, Jalpaiguri in GR case number 5086 of 2021 within 15 days from the date of the order, and shall be released on bail if the petitioner files a motion for bail. Stop. Next, learned counsel opinion for the petitioner submits that the petitioner could not comply with the condition imposed since the petitioner was unwell. Stop. Next, we find that the present application was filed on 28th February 2023, whereas the petitioner was to surrender before the CJM Jalpaiguri by 22nd November 2022. Stop. Next. However, on the submission made on behalf of the state, we consider it fit to allow and dispose of CRAN 1 of 2023 on the condition that the petitioner should surrender before the learned CJM Jalpaiguri within 4 days from today. Stop. The other conditions imposed by the order dated 7th November 2022 shall remain.
Failing which, my lord, is anticipatory bail.
If the petitioner fails to comply with this order, the petitioner's anticipatory bail will be rejected.
Good.
Allowed and disposed of. CRAN 1.
Item number 106.
I am appearing for the petitioner, lordship.
Yes.
Lordship, the petitioner was granted anticipatory bail on 7th of November 2022 with a condition to surrender before the learned court below within 2 weeks, lordship.
Yes.
Lordship, the petitioner could not surrender within 2 weeks, lordship. I am paying for extension of that time so that he can surrender and take regular bail, lordship.
Within 4 weeks means before by 8th December, by 7th December 2022. You have filed this in June 2023.
Lordship, due to his poor financial condition, he could not approve.
Financial condition. Why should the financial condition be relevant when you are asked to surrender? What is the connection?
Lordship, he has to furnish bail bond, lordship.
This CRAN 1 of 2023 is an application for extension of time to surrender before the learned Chief Judicial Magistrate, Jalpaiguri. Which was directed by a coordinate bench on 7th November 2022. Stop. The petitioner was to surrender within 4 weeks from the date of the order. Stop. Next, learned counsel, the petitioner submits that the petitioner could not comply with the condition since the petitioner was under financial stress. Stop. Next. Having considered the submissions made on behalf of the petitioner, we are of the view that that CRAN 1 of 2023 may be allowed and disposed of by extending the time to the petitioner, extending the time for the petitioner to surrender before the learned CJM Jalpaiguri. Stop. The petitioner shall surrender within, what is a good?
2 weeks.
Within 2 weeks from today. Stop. The other conditions passed in the order dated 7th November 2022 shall remain unchanged.
DPO.
Number 107.
Madam, I am for the petition. Petitioner granted privilege of anticipatory bail on 28th February 2023. There is a direction to surrender before the court.
কি নেই ওনারটা নাকি? 1 minute please. Yes.
There is a direction to surrender before the court within 4 weeks. The problem is that husband of the de facto complainant is a practicing advocate of the Mecklenburg court. For this reason, the petitioner could not able to arrange any surety. There is a condition to submit 2 registered surety.
No, husband of the de facto complainant.
Yes, my lord. There is a dispute between the petitioner and the de facto complainant.
Yes.
There is the allegation that.
So husband of the de facto complainant is a practicing advocate.
Yes, my lord. Practice.
So what is the difficulty for the petitioner?
No one willing to in favor of me to stand surety. My lord.
Very well. So now if we extend that time, then how will that help you? The situation remains the same.
Condition if your lordship waive the condition of registered surety instead of cash surety or personal bond. But there is a direction of registered. I will submit cash surety, no problem. And another
What do you
thing is
want?
PR bond, personal bond.
Personal bond or cash security? Registered cash security.
No, where is the registered cash security? In the order,
Man, order sheet there is a.
There is a 10,000 with 2 securities like
Man,
amount.
there is a registered surety.
There is no registered.
No, my learned colleague is asking you about the order passed by the coordinate bench.
Yes, madam. There
Is
is a
there a
direction.
direction to furnish the registered surety?
Yes, madam.
There is nothing in the, there is nothing. in
Good
the order.
surety means registered surety, man, local practice, my lord.
Practice is different thing.
And no one is willing to appear, and from different court, she is hiring advocate, my lord. This is the difficulty, my lord. The dispute. Her husband is an advocate, my lord.
Very well. So we shall, what is the
Personal-
prayer? How have you asked for the modification? Only for extension of time or what
No,
have you asked for?
Both, my lord. And waiver of this condition also. I prayed both, my lord.
Personal bond, cash surety.
Or personal bond, my lord.
Yes.
Helpful.
CRAN 1 of 2023 has been filed for modification of the conditions imposed by a coordinate bench in its order dated 28th February 2023, by which the petitioner, the petitioner's prayer for anticipatory bail was allowed, and the petitioner was directed to furnish a bond of, to furnish 2 sureties of like amount to the satisfaction of the arresting officer. Stop. Next, learned counsel appearing for the petitioner submits that since the husband of the de facto complainant is a practicing advocate in the Mecklenburg court, the petitioner has not been able to arrange for sureties in the court, in that court, despite the petitioner's best efforts. Stop. Counsel accordingly prays for modification of the condition to the extent of allowing the petitioner to furnish cash sureties and for extension of the time to do so. Stop. Next, having considered the submissions made on behalf of the parties, we are of the view that CRAN 1 of 2023 may be allowed and disposed of by modifying the conditions imposed by the coordinate bench and permitting the petitioner to arrange for cash sureties to the extent of, it will be how much amount? 10,000 each. So it will be 20,000. Yes,
It will be 20,000, my lord.
To the extent of rupees 20,000? Stop. This shall be done within a period of, yes, how much?
2 weeks.
2 weeks from date. The cash surety shall be arranged within a period of 2 weeks from date. Stop.
Cash security. Cash security to?
Yes, my lord.
Cash security.
Security. Last Adaku.
This matter, I'm praying for time. My lord. Can you fix this matter of 17th, my lord?
Like I'm for the state.
I put the defect form.
17th is all right?
My lord.
17th is all right?
17.
List this matter on 17th August 2023 as prayed for on behalf of the petitioner. We will
May I be permitted to mention, my lords?
Yes.
Madam, my lords, this petitioner has been running since the year 2002.
We can't understand. Microphone, please.
My lords, this petitioner has been running.
Running. So you have come to court running for what?
My lords, this petitioner has been running from pillar to post since the year 2002. But this matter has not proceeded.
2002.
Yeah, from the year 2002.
Don't use that word. It's the first time you're appearing in court. Then? Yes, so 2002, we are in 2023. What have you been done? What have you been doing all this while? What steps have you taken?
Number of petition the petitioner had filed in rejected. Petition was filed in 2019. After, also heard this matter, my lord, and a CAN application was also filed for complying with your order. But till date, this matter is not proceeded, my lords. Kindly take it up for hearing.
No. You should have show me. You mention the matter, showing me the dates as to what kind of steps you have taken. Before that, I will not allow any mention. Yes.
Contempt application.
At least mention which date. You just, this is the way, and I will include on the asking. At least say which date order was passed. Come back. Yes, call on the list, please.
My lord, may I permit to mention, my lord?
Yes.
My lord, the extension of interim order, my lord, I have already mentioned yesterday.
I can't understand what you're saying. Call on the list, please. Mute. Call on the list.
Extension of interim order.
May it please your lordship, my lord, I beg to appear for the petition of lord in item number 1.
Yes.
This matter I am appearing for the
61. It's item number 1. CO 61. Yes.
matter number 6.
Yes.
Lord, section 11 application. Lord,
But why does it say CO?
Lord, here, Lord, there is no Lord provision to mark Lord as AP. Lord, from the beginning of the
There is a
circuit.
provision. There it is a mistake.
But Lord, I don't know. Earlier also, whenever I moved to section 11, I found that CO it is.
No. Even the last orders passed by the coordinate bench says CO 61.
Now, whenever we file a section 11 application, the department Lord gives the number as civil revision.
Civil revision. How can it be civil revision? It's arbitration petition.
That is the system followed.
No. What system?
Earlier also, I moved Lord section 11 with the same number.
Yes.
Lord, I tell you, Lord, see what happened here. But my Lord may have a look at the order.
Mr. Chaudhary, why is it CO?
My lord, actually, it should be ought to have been AP.
Yes.
And the last occasion, the honorable court also pointed out this issue that
Yes.
it should be.
Yes.
But my lord, in this bench, my lord, some section 11 application is numbered as a AP, showing as an AP, but some also CO. So I have moved also certain matter before a lordship in section 11 level, and that is also.
But Mr. Chaudhary, CO is civil revision under Article 227.
Exactly.
How can it be a CO when there's a section 11 application? Mr. Chakraborty, I will not hear you unless the cause title is corrected.
Lord, it is given by the department.
Doesn't matter. Unless the cause title is corrected, I will not hear you.
My Lord may call for them, Lord, the registrar, Lord.
Registrar is on leave. He's not here.
But Lord, as far as I could, Lord, recollect on the last occasion, from my personal capacity, I tried to inquire. Lord, they say that here there is no provision in the filing, Lord, the system.
Mr. Chakraborty, that explanation is not acceptable. Article 227 CO being used for an AP, that is not acceptable. You tell me where I will keep the matter and I will hear you. But not before the correction, the cause title is corrected. And you should have taken steps. The matter was heard on 8th of August by the last coordinate bench.
But the numbering is given by the department, not the.
Doesn't matter. How can you even allow these things to continue? I don't understand.
Lord, may I most humbly suggest something?
Yes.
Lord, my Lord may keep both these matters on Wednesday. Lord, I would be coming before your Lordship's court physically, Lord, on the.
Why? You're on extended holiday or what?
No, I have one.
Yes.
No. Not a holiday, but the thing is, Justice Ganguly has fixed one matter Wednesday, 2 p.m. specially fixed. So, my lord, I have to be here. So, my lord, on what happens is not before Justice Tandon, I could not join on 8th virtually. Sometimes the link fails. So, I will come. My lord may call for a report from the department. Let them answer your lordships why it is numbered at CO and not AP. It is not, I believe, Lord, we have a very little control over the filing
No,
system.
doesn't matter, but I will not allow any,
kindly
I will
call for
not
a
pass any orders where it's not AP and CO,
My
but
lord may
CO.
call for a report. Yes.
Very well. Then it will have to go before the principal bench, but it cannot continue as CO.
My lord may transfer
Very
the
well.
file to the principal.
Yes,
My lord, let it be done.
admittedly, the present application is under section 11 of the Theke Capital, the Arbitration and Conciliation Act, 1996. Stop. However, for some strange reason, the cause title, the numbering of the matter appears as CO 61 of 2023. Stop. The court is informed that the department of the circuit bench does not have a mechanism to list matters under the heading AP. Stop. Next. The department is hence called to, the department shall file a report to explain this anomaly in the numbering of the matter. Stop. List this matter on 16th August 2023. Stop. The report should be filed within the returnable date.
Next matter is also.
But only the number is different, 77 is just.
Let the matter be called on, please.
Item number 2.
Same order.
Only 7.
What is the relationship to connected matters?
No, not connected for two highway construction. We were constructing NH, National Highway 10 and National Highway 55.
So you want appointment of arbitrator?
Yes.
And Mr. Chaudhary is objecting to that?
No. My only view is that only the suggestion that there should be arbitral tribunal should be consisting of 3 members.
3 members, and you want 1?
But then they agreed upon, if you lordship see the last order, is agreed upon the honorable court shall appoint on his independent way for the 3 consisting of 3 members.
But the clause says that parties will try to agree for 1. If not, then 3 arbitrators. But the state is insisting on 3 arbitrators. I want to get my matter decided. Your lordships may appoint any 3 independent persons, because why section 11? We initially, my lord,
Very well. If both of you are ad item on appointment of arbitral tribunal, then it's fine.
Yes, only.
Single arbitrator would have saved a lot of things for the parties, but since they have some
Very well. You're not an individual, you're a company.
Yes, we nominated Justice Jalpaiguri Bhattacharya, the retired Chief Justice of our Honorable Court. They nominated one of their ex-employees. So I said that under 12.5 and schedule.
Very well. That is fine. I'm sure Mr. Chaudhary knows the problems in 12.5.
Chaudhary also agreed, my lord,
Yes.
appoint anybody.
Very well.
I said that I have considered.
Yes.
Yes.
Anybody.
Next.
We shall come back for both the matters on 16.
Yes.
Yes.
Item number 3.
Yes, I Yes. Lord, item number 3, I am for the petitioner. This petitioner claiming interest and gratuity under revised RUPA 2019.
Have you, this is upon service?
Yes.
Have you served?
Yes.
You're serving, appearing with the state? Yes. Have you shared the order with him? देखे दो order to देखे दो. Revised PPO?
Revised PPO 2019. Here is the teacher of a school, retired.
Disposed of.
Item number 4.
Yes, my lord, I am for the petitioner. Revised 2019, my lord. Interest and gratuity and area payment.
Disposed of. And it will be good if you can give my court officer a soft copy of this. Can you do that? Soft copy of the order. It will be very quick then.
Item number 5.
Yes, my lord, I am for the petition. Revised 2019.
Just give a soft copy, at least one, then corrections can be made. Yes, allowed, disposed of.
Item number 6.
Yes. Revised 2019. The interest of gratuity and area payment.
Yes. Disposed of. Just give that, it's all are Shondip Kumar De. All of them. Yes.
Item number 7.
Yes, my lord. The my lord, interest of gratuity and area payments on revised 2019.
Disposed of.
Item number 8.
Yes. Revised 2019. 7.
Disposed of.
Item number 9.
Yes. Revised 2019. 7.
Disposed of.
Item number 10.
Revised 2019.
Disposed of.
Item number 11.
Give the copy to my court officer, please. Soft copy. Yes, disposed of.
Item number 12.
Revised 2019.
Disposed of. Disposed of. Disposed of.
I'm not state.
Disposed of.
Number 16.
I'm not.
Disposed of.
Number 17.
Disposed of.
Item number 18.
Disposed of.
Item number 19.
Disposed of.
Item number 20.
Disposed of. You should have mentioned in the morning. Why are you mentioning now? No. You have to mention it when yes, mentioning period is over.